At 9:07 on a Monday, my phone rang with the bank's main number. It was not my branch, it was the regional office downtown, the one that handled fraud escalations and commercial accounts. I let it go to voicemail because I was in the middle of reconciling a client's payroll file. The call came again immediately. Same number, I answered. A woman said my full name the way people do when they have already verified the spelling from a form. She asked if I could come to the branch on Grant Street within the hour. She did not say why, she only repeated twice that it would be better if I came in person. I asked if there was a hold on my account. She paused long enough to confirm that there was, then said she could not discuss details on a recorded line. She gave me a reference number and told me to bring identification. When I asked who had placed the hold, she said, "We received documents," and stopped there. I looked at the calendar. I had a client meeting at 11, an appointment I had moved twice already. I texted that I'd be 30 minutes late and grabbed my wallet, my passport card, and a folder I kept for the basics: lease, insurance, and anything else that had my address and a signature. On the way out of my apartment building, the front desk attendant flagged me down. There was an envelope behind the counter with my name handwritten in block letters. It was from the county probate court. Inside was a notice of an emergency hearing scheduled for 1:30 that afternoon, along with a petition for temporary guardianship and a request for immediate financial restrictions. The petitioner was my mother. The proposed guardian was my father. The allegations were short, typed in clean sentences that sounded like they had been taken from a template: diminished capacity, susceptibility to undue influence, impulsive spending, risk of self-harm. They cited no doctor. They cited family observation and bank concerns. The petition included an attachment titled Durable Power of Attorney, supposedly executed by me 2 weeks earlier, appointing my parents as my agents with authority over all financial transactions, including but not limited to bank accounts, securities, real property, and contractual obligations. It had my printed name and an ugly imitation of my signature. It was notarized. Under the notary block was a name I did not recognize, and a commission number. What made my throat go tight wasn't the accusations. Accusations can be answered. It was the timing. The hearing was the same day. It was already after 9. The bank wanted me there within the hour. The court wanted me at 1:30. Whatever my parents were doing, they had already set it in motion before I had woken up. In the elevator, I reread the bank line in the petition. Respondent's bank has expressed concern regarding respondent's erratic transactions and vulnerability. The bank had not expressed concern to me. The bank was calling me in and freezing my access. Someone had spoken for me. I did not call my parents. If I called, they would measure how much I knew by what I asked. I needed to see what existed in writing, with dates, with names, with logs. When I got to the Grant Street branch, the lobby looked normal. People were waiting for teller service. A man was opening a new account at a desk. There were no security guards watching me. I gave my name to the receptionist. She did not ask why I was there. She looked at her screen and said someone would be out. A few minutes later, a man in a navy suit stepped into the lobby and said my name quietly. He did not introduce himself until we were past the frosted glass door that led to the offices. "My name is Ellen Mercer," he said. "I'm the branch manager." He walked me into a small office with 2 chairs and a table. A binder sat on the table, closed, with a sticky note on top that had my reference number written in black ink. He asked for my ID. I handed him my driver's license and passport card. He compared them to something in the binder, then handed them back. He did not start with accusations. He started with procedure. "Your accounts are under a temporary administrative hold," he said. "That means outgoing transfers, wires, and cashier's checks are suspended. Your debit card may decline. Your direct deposit is not affected. Your rent check may not clear if it hasn't already." I asked him who requested it. He looked at the door, stood up, and stepped to the frosted window. He rotated the blinds down 1 notch, just enough that the slats closed more tightly. Then he sat back down. His voice dropped without drama. It became the tone people use when they are telling you what the script forbids them to say. He whispered, "Something's wrong." I watched his hands. They were steady, not nervous. He had made this decision consciously. He opened the binder and turned it so I could see. Inside is the power of attorney I had just seen in the court packet. It was a clean copy on heavy paper. It looked official. The notary stamp was sharp. Behind it was a cover sheet from my mother. It was polite and structured. It said she was delivering executed authority documents and requested immediate cooperation and confidentiality due to sensitive medical issues. It listed my account numbers. It included a copy of my driver's license and a voided check. I did not know how she had my voided check. Mercer slid the binder closer. This was presented in person, he said. Friday afternoon. 2 individuals. They identified themselves as your parents. They were polite, informed, and prepared. He said prepared, like it was evidence. I asked what they tried to do. He turned a page. They asked to move funds. They asked for cashier's checks. They asked about adding themselves to title. They asked about your safe deposit box. I didn't have a safe deposit box, which meant they were hunting. I asked how far they got. He kept his voice low. We didn't execute their requests. We initiated a verification process. I asked why. He looked at the power of attorney again and tapped the signature line with one finger. The signature doesn't match. The notary's commission number doesn't validate in our internal registry. The document uses language that's inconsistent with your previous legal instruments on file. And you have a standing instruction. I asked what standing instruction. He flipped to a page I recognized. 3 years earlier, after I had closed on my condo, and then sold it, I had filed a fraud alert with the bank, because my father had tried to open a line of credit in my name using an old address. The bank had made me sign a form. Require dual verification for any change of authority or ownership. I remembered signing it in a windowless office with a woman from risk management, who kept saying calmly that most fraud came from people the customer knew. Mercer pointed to that form. Your file flags family-initiated authority changes, he said. I asked if the bank had contacted me Friday. We attempted, he said. We called the number on file, we emailed, we mailed a verification letter, the email bounced. I told him my email hadn't changed. He nodded once like he had expected that. He pulled another sheet, an email change request submitted online. Thursday night, changing my email to an address I did not recognize. It was a free webmail domain. The request included my social security number and date of birth. My mother had filled out the court petition with those details in plain text. They hadn't needed to guess. How was the email change authorized? I asked. Your online banking credentials were used, he said. Correct username, correct password. 2-factor verification was completed. I felt the cold part then. The part where the system assumes that the person with the phone is the person. What number received the code? I asked. He showed me the last 4 digits. It was not mine. Mercer sat back. The number on file was changed the same night. He turned the screen toward me. The change log was clean. Timestamps, masked numbers, IP address, device ID. It showed my phone number removed and a new one added. It showed my email changed. It showed 2-factor completed. It showed the session originating from an IP address that geolocated to my parents' town. I had not been to their town in months. Mercer said, we are going to restore your credentials, but you need to do a few things in the right order. He slid a blank form across the table. First, we need you to sign an affidavit of unauthorized access. Second, we need to note that the power of attorney is contested. Third, we need you to provide a contact method not accessible to anyone else. As he spoke, he kept glancing at the door like someone might walk in and interrupt. Not fear, timing. I asked him if my parents were still in the building. He said no, but he didn't answer the question I hadn't asked. Whether the bank had told him I was coming. I said I had received a court notice. They filed for guardianship, I said. Emergency hearing today. His expression did not change, but his eyes narrowed the way they do when a puzzle piece fits. That's why, he said. He stood up and walked to the door. He opened it and looked out into the hall. He didn't call anyone, he just checked. Then he closed the door and came back. I'm going to say this carefully, he said. Banks don't decide capacity. Courts do, but banks do decide whether documents are valid. We have concerns. We will document those concerns. If a court issues an order, we comply. If a court asks our opinion, we respond with facts. Facts are what you need. I asked him what facts the bank had. He opened the binder and pulled out a printout from the lobby camera system. 2 still images from Friday afternoon. My mother at the counter, angled toward the desk, holding a folder. My father behind her, standing too close, looking over her shoulder toward the documents. Mercer pointed to the timestamp on the still. Then he pulled a note, a name of the banker who had taken the submission, a summary of what was said, and a line, customer did not appear aware, agents requested confidentiality, requested immediate movement of funds, red flags present, escalated. I asked if he would provide that to the court. He said, we will respond to a subpoena, But we can also give you a letter stating we have received contested authority documents and have placed a fraud-related administrative hold pending verification. He opened a drawer and pulled out letterhead. While he typed, I took out my phone and opened my call log. I had missed one call Friday from an unknown number, Saturday too. Both short, no voicemail. I checked my email, there was no bounce. There was nothing because my bank email had been rerouted to an address I didn't control. My parents had not started with a fight, they had started with access. Mercer printed the letter and signed it. It was dated and specific. It referenced the contested power of attorney and the online banking access changes. It did not accuse anyone. It only stated that the bank had initiated a verification process and that outgoing disbursements were on hold. He slid it across. Keep this with your court documents, he said, and change your phone number for two-factor, not your public number, a number only you control. I told him I would. He hesitated, then said, there's one more thing. He pulled a second copy of the power of attorney from the binder, this one with a blue stamp at the top. Received. On the back was a page I hadn't seen, a notary's journal entry copy attached by my mother. It listed my name, address, the type of document, and a thumbprint box. The thumbprint box was blank. Mercer's finger rested on the blank box. In this state, he said, notaries are required to record certain identity details for powers of attorney. They usually do, especially if the client is present. This looks like someone printed a template journal entry and forgot the part that requires an actual person. The bank manager didn't smile. He didn't soften the language. He let me reach the conclusion myself. My parents had filed an emergency guardianship petition using a forged power of attorney and hacked bank access, and they had done it quickly enough that the court hearing was set for the same day. I asked Mercer if the bank had been contacted by the court. He said, we received a fax this morning requesting information. That's part of why I needed you here. I asked him what the fax asked for. He opened the binder again and showed me a standard request for account balances and any suspicious activity. My mother had used the words bank concerns in the petition. The court had responded by asking the bank for confirmation. The bank had responded by flighting me account and calling me in. That was the first crack in my parents' plan. Not anger, not a confrontation, a log entry and a manager who knew how fraud looks. I signed the affidavit, I signed the contest form. Mercer took copies of my ID again, then walked me out through a side hallway so I didn't have to pass the lobby. At 10:11 I was back outside with the bank letter in my folder and the court packet under my arm. My phone buzzed with a text from my mother. Are you okay? Call me. We need to talk before court. Please don't make this harder. She knew I had been served. She knew I had a hearing. She knew I was already moving. I didn't answer. I drove straight to my apartment, not because I needed anything, but because I wanted to know whether they had been inside. If they had forged documents, changing locks wouldn't be out of character. When I pulled into the lot, I saw my father's truck parked near the entrance. It wasn't a coincidence, it was positioned for visibility. I parked 2 rows away and walked around the side of the building, not toward the lobby. I went to the leasing office first. The leasing office manager looked up when I walked in. Before I said anything, she slid a paper across her desk. It was a notice to vacate. It was dated Saturday. It said my lease was being terminated due to non-payment and unauthorized subletting. It cited an incident I had never heard of. Attached was a cashier's check photocopy with my name on it, supposedly returned for fraud. The leasing manager said, "Your parents were here this morning." I asked what they said. "They said you were not well," she said. "They said you were being taken into care. They wanted to arrange access to your unit to retrieve personal items and secure the place." I asked if she gave them access. She shook her head. "Not without you." But they were convincing. They had paperwork. I asked what paperwork. She handed me copies. One was the same power of attorney. Another was a letter on letterhead from a facility I recognized by name, a private mental health clinic in the city. It stated I was under evaluation and that my parents were authorized contacts. The letter looked real. It had a logo. It had a signature line. But the phone number at the bottom was wrong. I knew because my firm's insurance broker had once referred a client there. The number in the letter had a different area code. My parents were not just after money. They were building a narrative of incapacity that could be used everywhere. Bank, court, landlord, employer. I asked the leasing manager if she had called the number on the letter. She said no. She said, "I didn't want to violate privacy." They had counted on that. I asked her to print an account ledger showing my rent payments. She did. It showed every payment cleared on time. I asked her to put in writing that she had been approached by my parents claiming I was incapacitated and requesting access, and that she denied access. She hesitated, then agreed when I said it would protect the building as much as it protected me. While she typed, I saw movement outside the office window. My father was standing in the lobby, hands in his pockets, looking toward the leasing desk. He wasn't here to talk, he was here to be seen. The office manager finished the letter and signed it. I asked if the building had cameras covering the lobby. She said yes. I asked her to preserve the footage from that morning and from now. She wrote down the times. When I walked out, my father stepped into my path without touching me. He kept his voice calm. "You're making a mistake," he said. I didn't answer. He glanced at the folder under my arm. "We filed because we had to," he said. "You've been unstable." I looked at him for a second, long enough to show I heard him, then kept walking. He followed a step behind, matching pace. "If you show up in court like this, it's going to look bad," he said. "If you cooperate, the judge will see we're trying to help." "Stop," I said, not loud. He stopped. He didn't argue, he watched me walk away. That restraint confirmed what mattered. He believed he had procedure on his side. He believed his paperwork would carry him. He didn't need to shout because he thought the system would do the work. Back in my unit, I checked the doorframe. There were no scratches, no signs of forced entry. I checked the closet where I kept old files. My folder of tax returns was still there. My passport was in its spot. Nothing obvious was missing. Then I checked the one thing my parents would want first if they planned to take control. My personal records. The file box was slightly rotated, not in the same alignment I had left it. One folder was half an inch out. It was the folder labeled Trust Estate. 3 months earlier, my grandmother had died. My mother's mother. The estate was not large, but it included a paid-off house and a brokerage account. My mother had told everyone repeatedly that there was no conflict, that everything was simple, that it would be split evenly between her and her brother. 2 weeks after the funeral, my uncle called me. He asked if my mother had told me about the amendment. I asked what amendment. He said he had received a copy of a trust amendment signed 6 months before my grandmother died, naming my mother as sole successor trustee and primary beneficiary, with my uncle receiving a sentimental distribution and nothing more. My uncle said he believed it was forged. He asked if I would look at it because I worked with documents and signatures. I told him I would. When I asked my mother about it, she said my uncle was bitter, and that my grandmother had changed her mind. She said, "Don't get involved." That was when I started requesting records. Quietly. I asked the attorney who had supposedly drafted the amendment for a copy. I asked for notarization details. I asked for the original execution. I asked for the notary journal entry. The attorney's office didn't respond. Then my mother stopped taking my calls. Now the trust folder in my apartment looked handled. My parents' guardianship petition wasn't random. It wasn't about my spending. It was about controlling my ability to challenge something. If I was declared incapacitated, I couldn't request records. I couldn't contact attorneys. I couldn't file objections. My parents could. I opened the trust folder. The top document was a copy of the original trust my grandmother had created 10 years earlier. Beneath it was my own note, list of questions, names, dates. The one missing item was my copy of my grandmother's signature exemplars, the ones I had printed from old letters and checks to compare to the amendment signature. My apartment hadn't been broken into, but someone had been inside. Not by force, by access. My father had always insisted on spare keys for emergencies. Years ago I had refused. Then, after a plumbing leak while I was traveling, I had let the building give him temporary access to let the plumber in. I had never asked the building to revoke that access. I have assumed it was one time. I called the leasing office and asked, calmly, whether they had a record of any key access granted to my father. The manager said she could check. She put me on hold. When she came back, she said there was an entry, emergency access granted 3 months earlier for plumbing, and it had not been marked as revoked. She said, "I didn't realize." I asked her to revoke it immediately, and to note in the file that my parents were not authorized for access under any circumstances without my explicit written consent. She agreed. I didn't thank her. Not because she didn't deserve it, but because gratitude softens what needs to be a clear record. I needed her to remember this as a liability issue. At 10:46 I made 3 calls. First I called my attorney. I had hired one the previous year for a contract dispute. He wasn't probate counsel, but he understood emergency hearings. His assistant answered and said he was in court. I said I needed him to call me back within 30 minutes, and that it involved an emergency guardianship petition filed against me. Second, I called the probate court clerk's office. I asked whether remote appearances were allowed. The clerk said no for emergency guardianship, not unless pre-approved. I asked what evidence rules applied. The clerk said the judge could consider affidavits and documents. Third, I called the non-emergency sheriff's office and asked about the process server entry. The deputy transferred me to civil. Civil confirmed that the petition had been filed Friday late afternoon, and that temporary orders had not yet been granted. The hearing at 1:30 was to determine whether temporary guardianship and financial restrictions would be imposed. So my accounts were frozen by bank policy, not by court order. The court hadn't yet acted. My parents were trying to create the impression that the court had already decided. At 11:02, my attorney called me back. He didn't waste words. "Tell me what's in writing," he said. I summarized. Emergency petition, forged POA, bank hold, landlord approached, facility letter, and the trust issue. He paused when I mentioned the bank letter and the online credential change logs. "Bring everything to court," he said, "and do not communicate with them except in writing. If you speak, it becomes a he said, she said. If you write, it becomes an exhibit." I told him I needed representation at 1:30. He said, "I'm not probate counsel, but I can appear to object to procedure and preserve rights. I can also call a colleague." I asked him to do both. He asked if I had any medical documentation disproving their claims. I told him I had an annual physical record, nothing else, and no mental health history. He said, "In emergency guardianship, they don't need much to get a temporary order if the judge is cautious. Your job is to show the petition is not credible and the documents are compromised." He told me to do 3 things before noon. 1, he said, file a written objection with the court clerk, even if it's short. 2, get the bank manager's letter notarized if possible. 3, secure your digital accounts. Change passwords, enable 2-factor to your own number, and generate logs. I asked why logs. He said, "Because the person who controls the narrative controls the first order. We need timestamps." At 11:14, I opened my laptop and began changing passwords systematically. Email, banking, cloud storage, phone carrier. When I tried my phone carrier account, I found the password had been changed. I clicked Forgot Password. The recovery email listed was not mine. I drove to the carrier store and walked in with my ID. I asked them to print the change history on my account. The employee said they couldn't print internal notes. I asked them to tell me whether a SIM swap had been performed. He checked. He said, "Yes, Thursday night, new SIM activated." That explained the 2-factor. My parents didn't just guess my password, they took control of my phone number by transferring it to a SIM they held. They could receive my bank codes, they could reset emails, they could impersonate me cleanly within the system. I asked the carrier employee to lock the account and issue a new SIM to me. He said it required a security PIN. I said I didn't know it because I hadn't set one. He showed me the account notes. A security PIN had been added Thursday night. I felt the shape of it. They had walked into a store with my information and set it. I asked the employee what identification had been used for the SIM swap. He said he could not disclose. I asked if there was video. He said stores had cameras. I asked him to preserve it. He said he couldn't. I asked for the store manager. The manager came out, listened, then said they could place a preservation request if law enforcement requested it. I asked for a printout of any customer-facing record, SIN change confirmation, timestamp, location. The manager printed what he could, a transaction receipt showing the date, time, and store number. That receipt mattered more than his words. It created a record that the change occurred and that I was disputing it. At 11:58, I walked out of the carrier store with a new number assigned, my old number locked, and a note on the account indicating suspected identity fraud. I sat in my car and typed a 1-page objection to the guardianship petition on my phone. It was not emotional, it was procedural. I stated that the power of attorney attached was forged, that my bank accounts had been accessed without authorization, that a SIM swap had occurred, that my landlord had been approached with false claims, and that the petition appeared retaliatory and connected to a disputed trust matter. I requested denial of emergency relief and asked the court to order a forensic review of the notary commission and the alleged execution. I printed it at a shipping store near the courthouse and filed it with the clerk at 12:27. The clerk stamped it received and handed me a copy. At 12:41, as I was walking out of the courthouse, my mother called from a blocked number. I didn't answer. A minute later, a text came through from my father. "We're in the parking lot. If you have any respect left, Talk to us before you humiliate the family. I stood on the courthouse steps and looked down at the street. I could have gone to the parking lot and tried to reason with them. But reason was irrelevant. This wasn't a misunderstanding, it was an attempted takeover built from documents and access. I walked to a bench across from the courthouse and waited for my attorney. At 1:06 he arrived with a colleague, a probate litigator named Denise Park. She was younger than I expected, with a flat folder under her arm and an expression that suggested she had already skimmed the petition on her phone. She asked to see everything. I handed her the court packet, the bank letter, the carrier receipt, and the leasing office letter. She read quickly. When she reached the notary block on the power of attorney, she paused. "Do you recognize this notary?" she asked. "No," I said. She turned the page and looked at the commission number. "We're going to check this right now," she said. She walked to the clerk's counter and asked if the courthouse had a notary database terminal. The clerk said no. Park took out her laptop and tethered to her phone. She searched the state notary registry. She typed the commission number. Her face didn't change, but she rotated the screen slightly so I could see. The commission number returned a different name, not the one on the document. Park clicked again and searched by the notary name printed on the document. No results. She said quietly, "Either it's not a real notary, or the commission is fabricated, or the stamp is stolen." She didn't look pleased, she looked focused. My attorney said, "That's the procedural flaw." Park corrected him. "It's not a flaw, it's invalid execution. That changes how the judge hears this." At 1:24 we walked into the courtroom. It was smaller than a criminal courtroom, with fewer seats and no jury box. A deputy sat near the door. The judge's bench was elevated but not imposing. My parents were already there, seated in the front row. My mother wore a soft cardigan and held a tissue like a prop. She didn't need yet. My father sat beside her, hands folded, looking straight ahead. They did not look at me until I sat down. When they did, my mother's face shifted into something rehearsed. Relief mixed with worry. She mouthed, "Please." I did not respond. The case was called at 1:33. We stepped forward. Park introduced herself as my counsel for purposes of objecting and contesting the petition. My mother's attorney introduced himself. He was older, measured, and spoke in the tone of someone who trusted the court's caution. The judge began by summarizing the petition. Allegations of incapacity, vulnerability, financial risk, request for temporary guardianship and immediate restrictions, and a power of attorney attached as evidence that I had recently granted authority to my parents. Then the judge looked at me. "Do you contest this petition?" she asked. Park answered. "Yes, Your Honor, we contest the allegations and we contest the validity of the power of attorney. We also have evidence of unauthorized digital access, including a SIM swap and bank credential changes, which suggest the documents and activities cited in the petition were manufactured." The judge's expression remained neutral. "Emergency guardianships are granted only when the court finds immediate risk," she said. "Petitioner, do you have medical evidence?" My mother's attorney said they did not have a physician affidavit, but had family observations and recent erratic behavior, including unusual transfers and inconsistent communications. Park said, "Your Honor, the bank has placed an administrative hold, not because of the respondent's behavior, but because the bank believes the authority documents presented by the petitioners are suspicious. We have a signed letter from the branch manager to that effect." She handed the letter to the bailiff. The bailiff gave it to the judge. The judge read it carefully. The courtroom was quiet. My mother's tissue remained unused. The judge looked up. "This letter states the bank received a contested power of attorney presented by the petitioners," she said, "and that the bank observed signature mismatch and issues with verification." My mother's attorney began to speak. The judge raised a hand. "Let me finish," she said. She turned to my mother. "Mrs. Hale," she said, using her married name, "did you present this power of attorney to the bank?" My mother's attorney answered for her. "Yes, Your Honor, in an effort to protect." The judge interrupted. "I asked the petitioner," she said. My mother's voice was soft. "Yes," she said, "we did." The judge turned to my father. "Mr. Hale, were you present?" "Yes," my father said. The judge looked back down at the power of attorney attached to the petition. "Did your daughter sign this in your presence?" My mother's eyes flicked to her attorney. She said, "Yes." Park did not react. She waited until the judge looked back at her. "Your Honor," Park said, "we request permission to approach with an exhibit comparing the notary commission number on the power of attorney to the state registry." The judge nodded. Park handed the judge a printout from the state registry showing that the commission number belonged to a different notary name than the one printed on the document, and that the printed notary name did not exist in the registry. The judge read it. Then she looked at the notary block again. The temperature in the room changed without anyone raising a voice. The judge did not need drama. She had a mismatch in black and white. My mother's attorney tried to pivot. Your Honor, if there is a clerical error with the notary, the family's concerns remain. The court can still issue temporary relief to ensure. The judge leaned forward slightly. A clerical error is when a digit is transposed, she said. This suggests the power of attorney is not properly notarized. If it is not properly executed, it is not evidence of the respondent granting authority. It may be evidence of something else. My mother's face tightened around the eyes. She kept the rest of it soft. The judge turned to Park. You mentioned unauthorized digital access, she said. Do you have documentation? Park handed up the carrier receipt showing a SIM change Thursday night, and the bank letter referencing online banking credential changes, and an IP location matching my parents' town. The judge read the carrier receipt. She asked me, directly, were you present at the carrier store on Thursday night? No, I said. Did you authorize a SIM swap? She asked. No, I said. Did you change your bank email and phone number? She asked. No, I said. She looked at my mother. Did you or your husband have access to your daughter's phone? She asked. My mother's attorney objected to relevance. The judge overruled. It's relevant to whether the alleged financial activity is authentic, she said. My mother said, we've helped her before. We've had her passcode in emergencies. That was the first admission of access. It wasn't dramatic. It was a small statement that connected to the logs. The judge asked, do you currently possess her phone or SIM? My father said. No, Park said. Your Honor, may I also offer a letter from the respondent's landlord, indicating the petitioners approached them today, claiming incapacity and seeking access to the respondent's apartment. The judge took the letter. She read it once, then again slower. My concern, the judge said, is that the court is being asked to grant extraordinary power based on allegations that appear to be supported by fabricated documents and unauthorized access. My mother's attorney tried again. Your Honor, families are messy, my clients are frightened, they may have acted imperfectly, but the purpose is protective. The judge's voice stayed calm. Protective purpose does not authorize fraud, she said. She turned to my parents. This court does not grant emergency guardianship as a tool in family disputes, she said. If you have evidence of incapacity, you bring medical evidence. If you have evidence of financial exploitation, you bring bank records obtained lawfully. What I am seeing is an attempt to obtain control first and justify it after. My mother's tissue finally moved. She dabbed her eyes once. It was small and careful. The judge did not respond to the tissue. She responded to the paper. She asked my mother's attorney, Counsel, did you verify the notary commission? He hesitated. Your Honor, my clients provided the document. I did not independently verify the commission. The judge nodded like she had expected that answer too. She then asked Park what relief we were requesting. Park said, we request immediate denial of temporary guardianship, an order striking the power of attorney as invalid, and a protective order prohibiting the petitioners from contacting the respondent's financial institutions and landlord using claims of incapacity. We also request referral to the district attorney from review of potential forgery, identity theft, and attempted financial exploitation. The judge took a breath and looked down at her notes. When she spoke, her words were precise. Temporary guardianship is denied, she said. The petition is dismissed without prejudice, meaning it may be refiled with proper evidence. However, given the irregularities here, any refiling will require a physician affidavit and will be assigned for full hearing with notice and time for response. My mother's attorney started to speak. The judge held up a hand. No, she said. I'm not done. She continued. The attached power of attorney is not accepted by this court as valid. The mismatch between the notary commission and the registry is significant. I am issuing an order that the petitioners are to cease presenting this document to any institution as authority. Violation will be treated as contempt. She looked directly at my parents for the first time in a way that was not neutral, not angry, just direct. I am also issuing a temporary protective order prohibiting the petitioners from contacting the respondent's bank, landlord, employer, or medical providers on her behalf, absent her written consent or further court order, she said. This is to prevent further harm while the parties sort out legitimate issues. Then she addressed the referral. Based on the record presented today, I will direct the clerk to forward this file to the district attorney's office for review, she said. That is not a finding of guilt. That is a recognition that the court has encountered potentially criminal conduct. The deputy near the door straightened slightly. The court had shifted from family court posture to institutional posture. It was no longer about concern. It was about documentation. My mother did not cry out. She did not collapse. Her face went still. My father's jaw moved once like he was adjusting his bite. The judge looked at me again. "Miss Hale," she said, "you should consider placing your own safeguards in place. A trusted agent of your choosing, perhaps a professional fiduciary, and securing your digital accounts. The court cannot protect you from every misuse of access, but it can respond when presented with records." I nodded. "Yes, Your Honor." At 2:04, the hearing ended. We walked out of the courtroom. My parents followed a few steps behind. In the hall, my mother said my name once, softly, as if that would pull me back into the role she needed. Park turned and faced her, not aggressively, but as a boundary. "All communication goes through counsel," she said. My father's voice stayed calm. "This isn't over," he said. Park didn't respond. She didn't need to. The judge had already answered him in writing. Outside the courthouse, my attorney and Park stood with me on the steps. Park said the next hours mattered because my parents would try to salvage the plan elsewhere. "They'll go back to the bank," she said. "They'll go to your employer. They'll try another judge. The protective order helps, but you should assume they'll test it until someone enforces it." She told me to do 5 things immediately. 1. Serve the bank with the court order and ask for a fraud investigation report. 2. File a police report for identity theft and SIM swap fraud, and provide the carrier receipt and bank letter. 3. Notify my landlord in writing of the protective order. 4. Notify my employer's HR that a false guardianship petition had been filed and dismissed, and that any inquiries from my parents were prohibited. 5. Lock down my credit. Freeze bureaus, place extended fraud alerts, and request reports. It was a list. It wasn't advice wrapped in comfort. It was a procedure for preventing the next attempt. At 2:26, we were back at the bank. Mercer met us in the office without the blinds being adjusted this time. He had already received the court's fax because Park had asked the clerk to send it. Mercer read the order carefully. He did not show satisfaction. He showed relief that the bank's risk assessment now had court backing. "We can maintain the hold until we complete our fraud investigation," he said. "But we can restore your access under new credentials today." He had a fraud specialist on speakerphone from the regional office. The specialist asked me questions with the same tone as Mercer, calm, precise, designed to establish facts. When did I last have access to my online banking? When did I last receive a 2-factor code? Had I shared passwords? Had I granted anyone authority? Did anyone have access to my mailbox? I answered each in short sentences. The specialist asked if I suspected who had done it. I said my parents. They filed a guardianship petition today using a forged power of attorney. The court dismissed it and issued an order prohibiting them from presenting the document. There was a pause. Then the specialist said, "We will request copies of the court order for our file." Mercer made copies. Then Mercer told me the part he hadn't told me earlier. "On Friday," he said, "your mother asked about the trust account." I said, "What trust account?" He slid a paper across the desk. It was a screenshot of an internal search result showing an account type labeled "Trustee Account," opened 6 months earlier, with my grandmother's name in the title. My mother had opened a trust-related account at this bank without telling me. She had likely used it to move estate funds. Mercer said, "She asked whether you had any authority over it. She asked whether you could challenge transactions. She asked what would happen if you were declared incapacitated." He looked at me steadily. "That was the moment I knew her goal wasn't to help you, it was to prevent you from acting." The bank specialist asked Mercer to send the internal notes to fraud. Park asked Mercer to preserve all records, camera footage, teller notes, document copies, and any call logs with my mother. Mercer nodded. "Already done," he said, "and I will personally sign a declaration if subpoenaed." At 3:18, I left the bank with new credentials, an account freeze still in place for outgoing transfers until the fraud review finished, and the name and direct number of the bank's fraud case manager. The day was not over. It had only shifted from emergency hearing to enforcement. At 3:44, I was at the police station, filing an identity theft report. The officer at the desk looked tired, not skeptical. He asked for documents. I gave him copies of the court order, carrier receipt, and bank letter. He read the notary mismatch information and asked me, "Do you have the original power of attorney?" I said no, only copies. He said we can request the original from the petition file. We can also request notary records. He typed while I spoke. He asked for my parents' names and addresses. I provided them. He asked if I wanted them arrested today. I said, I want the report filed and the evidence preserved. He looked up. "You understand this could escalate," he said. "I understand," I said. He nodded once and continued typing. At 4:32 I emailed my landlord the protective order. I attached the leasing manager's letter and asked for written confirmation that my parents were not authorized and that any prior access permissions were revoked. I asked the building to preserve camera footage from the lobby that morning and afternoon. At 5:05 I emailed HR at my firm. I kept it short and factual. A false guardianship petition was filed and dismissed. A court order prohibited my parents from contacting my employer. Any inquiries should be directed to counsel. I attached the order. At 5:29, my mother left a voicemail on my new number, which she should not have had. Her voice sounded controlled. "I don't know what you think you're doing," she said. "We were trying to keep you safe. You're going to regret letting strangers turn you against your family." She didn't mention the notary. She didn't mention the SIM swap. She didn't mention the forged signature. She only described motive, because motive is harder to disprove than a stamp number, until the system requires records. I forwarded the voicemail to Park. It was a violation of the protective order, not dramatic, but useful. That night, I didn't sleep much. I sat at my kitchen table and built a timeline. Thursday night, SIM swap. At carrier store, phone number moved. Security can added. Thursday night, bank online session from parents town IK email changed. Phone number changed, two-factor completed. Friday afternoon, parents present forged POA at bank. Attempt to move funds, attempt to gain access. Saturday, court petition prepared and filed late Friday. Notice served Monday morning. Landlord approached Monday morning. Monday, bank calls me in. Court hearing. Petition dismissed. Protective order issued. Police report filed. Each line had a document attached. Receipt, letter, court stamp, bank log. It was not emotional, it was a spine. At 7:12 the next morning, Park called me. The district attorney's investigator reached out, she said. They want the carrier receipt and the bank fraud case number. They're also asking about your grandmother's trust. I told her about the missing signature exemplars and the shifted folder. I told her about my uncle's call and the alleged trust amendment. Park said, "This is bigger than the guardianship." The guardianship was a tool. The underlying motive is control of estate assets and preventing scrutiny. She told me to meet her that afternoon to prepare a petition in probate court regarding the trust, request for accounting, request for suspension of my mother as successor trustee, if she was acting, and request for appointment of a neutral fiduciary pending investigation. I asked how quickly that could happen. She said, "Fast if you have enough to show the court that records are being manipulated." At 9:23 Mercer called me. He said, "Our fraud team pulled the IP logs in more detail. The online banking session originated from a home internet provider registered to an address. It matches your parents' address on the petition." He paused. "We also pulled lobby camera footage. Your mother presented the power of attorney in the facility letter. She also presented an envelope." I asked what was in the envelope. He said, "Cash. She attempted to deposit cash into your account, then immediately request a cashier's checkout. That pattern is common. Create a transaction trail to justify later claims of erratic behavior or unusual deposits. If she could show cash deposits and rapid withdrawals, she could describe it as instability, or she could use it to launder the origin of funds." Mercer said they refused the transaction. The cash was returned. It was noted. I asked him if he could provide a written declaration with the IP address and the camera preservation statement. He said yes. He asked for Park's email. I gave it. At 11:08, Park and I met in her office. She had already drafted 2 filings, a petition for accounting and a motion for temporary suspension of trustee powers based on evidence of forged documents and attempted misuse of court procedures. She asked me for one thing I hadn't brought: proof that my mother had control of my grandmother's trust assets. I told her about Mercer's trust account screenshot. Park said, "We need more. We need the trust instrument and we need to know where the assets are." I said I had the original trust copy, but not the amendment. Park nodded. "Then we subpoena," she said, "and we request emergency relief because she's already demonstrated willingness to fabricate." At 12:02, Park's assistant called the courthouse to schedule an emergency probate hearing on the trustee motion. The clerk gave a slot, 9 a.m. 2 days later. 2 days is short in court terms, but long in fraud terms. It gave my mother time to move assets. Park said, "We're going to request a temporary restraining order on trust distributions today, ex parte if necessary, based on the guardianship record and bank fraud record." I asked what ex parte meant in this context. "It means we ask without notifying her first," Park said, "because notifying her gives her time to move money. My parents had used that approach against me. Now the system's own logic would be used against them." At 2:17, Park filed the trust restraining request along with exhibits, the dismissed guardianship petition, the notary mismatch printout, the bank manager's letter, the carrier receipt, and the police report number. At 4:40, the probate judge signed the order, temporary restraint on trust distributions, and a requirement that any trustee provide an accounting within 10 days and preserve records. It wasn't a final victory. It was a lock placed on a door before the person inside could move what mattered. That evening my uncle called me. He didn't say, "I told you so," he said, "She called me." He said my mother told him I was not well, and that the court had appointed her to handle things, and that he needed to sign a release of claims for the estate to be settled. He asked if it was true. I said, "No. The court dismissed her petition." He exhaled once. "She sounded confident," he said. "Confidence isn't a document," I said. He went quiet, then said, "I kept the copy of the amendment she sent me. I'll bring it to your attorney." That was the next piece, the document itself. 2 days later, at 8:48 a.m., I stood in probate court again, this time with Park, my uncle, and a file that had grown thick with stamped pages. My mother arrived with her attorney, the same one from the guardianship hearing. My father was with her again. They looked less composed, not panicked, just less rehearsed. They hadn't expected their first move to collapse so quickly. They had expected to be the ones holding orders and making calls. The probate judge started with the restraining order already in place. He asked my mother, as purported trustee, to explain. Her attorney tried to frame it as family conflict and to portray me as a disruptive grandchild interfering in a matter between siblings. Park didn't argue emotionally. She placed the guardianship dismissal order on the bench, then the notary registry mismatch, then the bank fraud declaration, then the police report number, then the restraining order the judge himself had signed. She said, "Your Honor, this is not a family disagreement, it's a pattern, fabricated authority documents, misuse of institutions, and attempts to control assets by disabling anyone who might challenge." The judge asked my mother if she had the original trust and the original amendment. My mother's attorney said they had copies. The judge said, "Copies are not sufficient given the allegations," and ordered production of originals within 48 hours. Park then introduced my uncle's copy of the trust amendment. She didn't claim it was forged by rhetoric. She pointed to execution details. The amendment stated it was signed in my grandmother's kitchen, with 2 witnesses and a notary. The notary name on the amendment was the same printed name as on the forged power of attorney used against me. Park handed the judge the state registry printout again. The notary did not exist. The judge's face did not change much, but his voice became narrower. "Mrs. Hale," he said, "are you telling this court that a non-existent notary notarized your mother's trust amendment and your daughter's power of attorney?" My mother began to speak, then stopped. She looked at her attorney. Her attorney stood and said, "Your Honor, my client relied on a mobile notary service. It's possible there was an administrative error in the stamp." The judge said, "An administrative error does not create a person who does not exist." He turned to Park. "What relief are you requesting today?" he asked. Park said, "Appointment of a neutral fiduciary as temporary trustee, immediate freeze on trust distributions, and an order compelling production of all trust assets records, including bank statements, brokerage statements, and any real property transfer documents. We also request that any notary involved be referred to the Secretary of State for investigation." The judge looked at my mother's attorney. "Response?" he asked. The attorney attempted to argue that freezing the trust would harm administration and that appointing a neutral fiduciary would create costs. The judge said, "Costs are preferable to theft," and signed an order appointing a professional fiduciary as temporary trustee on the spot. It was not a theatrical moment. It was ink on paper. But I watched my mother's shoulders change slightly, as if a weight she had assumed was hers had been lifted off and placed onto someone else's desk with a case number. After the hearing, the professional fiduciary introduced herself to both sides. She spoke in a neutral administrative tone. She requested keys, account numbers, and originals. She set deadlines. My mother did not look at me as she left the courtroom. My father walked beside her, closer than before, not as a protector but as a man trying to keep her moving in a straight line. Outside, Park said, "Now we wait for records. Records will either clear her or bury her. Either way, the system needs paper." At 3:03 p.m. that same day, I got a call from an investigator with the district attorney's office. He said they had opened a case based on the court's referral. He asked if I would provide a formal statement. I said yes. He asked one question that mattered more than all the others. "Do you believe your parents intended to steal money? Or do you believe they were helping you?" he asked. I answered the only way that matched the documents. "I believe they intended to control what I could do," I said. "They used a forged power of attorney and a SIM swap to access my bank. They filed an emergency petition to get authority. They approached my landlord and my uncle using the same story. They did not bring medical evidence, they brought paperwork that doesn't validate." There was a pause. Then he said, "That's clear." Over the next week, the professional fiduciary's office began issuing formal demands to my mother for trust records. Banks responded quickly to fiduciary letters. Brokerages responded slower, but they responded. Each response created a trail my mother could not rewrite. The temporary trustee found that the trust house had been transferred into a newly formed LLC 2 months before my grandmother died, with my mother listed as managing member. The deed had been notarized by the same non-existent notary. The trustee found that the brokerage account had been liquidated in chunks under the reporting threshold, then moved into the trust account at Mercer's bank, then out to another institution. The outbound transfers had memo lines that looked like routine bills but were round numbers. When the trustee asked my mother for the original amendment, my mother said it had been misplaced during the funeral period. The trustee documented that statement as well. The district attorney's investigator called again and asked for the trustee's findings. Park coordinated because information sharing had to follow rules. The trustee's office prepared a report that was factual and clean: transactions, dates, notarizations, and missing originals. 2 weeks later, my parents were served with a criminal summons for identity theft related to the SIM swap and attempted bank fraud. Separate charges related to forgery and fraudulent notarization were under review. They weren't arrested in front of anyone. They were summoned like people who had been caught by paperwork, not by a dramatic scene. My mother's attorney withdrew from representation. That happens when the client's story cannot be supported without implicating the attorney's own duties. My mother tried to contact me once, through a cousin. The cousin said my mother was willing to talk. Park responded with a single sentence: "All communication through counsel." The cousin did not try again. At the end of the month, the probate court held a full hearing on the trust. The temporary trustee presented the accounting. My uncle sat beside me. My parents sat on the other side with a new attorney who spoke less and listened more. The judge entered a final order. My mother was removed as successor trustee. The professional fiduciary would remain. The trust house transfer to the LLC was voided pending investigation. The brokerage transfers were flagged. The court ordered restitution procedures if misappropriation was confirmed. My mother did not shout. My father did not look at me. The judge didn't scold them. He didn't need to. He issued orders with deadlines and consequences. Afterward, I went to Mercer's branch one last time to sign final fraud remediation paperwork. The bank restored full access and reversed the unauthorized changes. They issued me new account numbers. They placed a permanent note requiring in-person verification with photo ID for any authority change, no exceptions. Mercer walked me to the door. Before I left, he said, "Most people think betrayal looks like a fight. Most of the time it looks like a form." I nodded. "And a timestamp," I said. He didn't respond, but his expression acknowledged that he understood the point. In the weeks that followed, I replaced my locks, changed my phone number again, and moved my sensitive records to a safe location my parents did not know. I executed my own power of attorney, naming a professional fiduciary as agent, not because I expected incapacity, but because I understood how quickly people will try to use that concept as a weapon. I requested my credit reports and saw the early attempts: an inquiry for a personal loan, a credit card pre-approval, a Trilogy account start. They had been blocked by the freeze. Each block generated a letter. Each letter became part of the record. My parents' plan didn't collapse because I found the right words. It collapsed because a bank manager recognized an invalid pattern and was willing to document it, and because judges respond to verifiable inconsistencies faster than they respond to family narratives. When people ask me now how it happened, I don't describe my feelings. I describe the sequence: the SIM swap receipt, the IP log, the notary registry mismatch, the bank's administrative hold, the court's protective order, the trustee's accounting. Those are the things that held. If you've been through something like this, or you're watching it happen in your own family, you don't need to convince anyone with intensity. You need to collect what can be time-stamped and verified, and you need to get it in front of the right authority before the next move happens. If you want, share in the comments what kind of record ended up mattering most in your situation, and if you're following this series, subscribe so you don't miss the next story.